welcome. This is another session in our SME presentation series. My name is Alicia Wood, and with my colleague Lachlan Goddard, we will today be presenting on what we've coined the ABCs of debt recovery. First, I'll commence with an acknowledgement of country. We acknowledge this land that we meet on today is the traditional lands of the Kaurna people, and that we respect their spiritual relationship with their country. We also acknowledge the Kaurna people as the custodians of the Adelaide region, and that their cultural and heritage beliefs are still as important to the living Kaurna people today. We also pay respects to the cultural authority of Aboriginal people visiting and attending from other areas of South Australia. And with housekeeping, apologies for the renovations in our foyer. If you do need to use the bathroom, you'll have to speak to someone at reception and they will take you down to level 10 during the hour. Right, I'll just proceed to give you a little bit of an overview about what we're going to talk about today. So first of all, contracting. We'll cover the steps that you can take in preparation for and to ensure that you are paid within terms, and then the steps that you can take to aid enforcement if payment is not made. Then we'll move on to self-help remedies, which will include initial practices that you can implement already in your business to identify when payment terms are not met and to ensure prompt payment. Steps you can take before you see a lawyer. And seeing a lawyer. So when you see a lawyer, we'll also cover what's involved in enforcing a debt, and that will include pre-action steps that are required under our court rule, informal payment arrangements, and so forth. And then we will deal with court proceedings where they're undefended and undisputed, and then where they become a bit more complex and are defended and genuinely contested, for instance, a counterclaim. And then we'll move on to enforcement, where we have remedies available through our court system yourself, through warrants of sale and payment orders, and then we will touch on bankruptcy and winding up. So I'll pass now to my colleague Lachlan.
Thanks, Alicia, and thank you for everyone in the room to attend a presentation about debt recovery. It's probably not the most fun way to spend your day, but anyway, we're here, so let's do it. First, I want to talk to you about the importance of getting your contracts right. And you might be thinking or wondering why we're starting a presentation about debt recovery by talking about the front end, what you're doing with your clients, and you're actually entering into an agreement with them. But as you'll see from my presentation, and as we move into Lisa's presentation, the events that take place when you are contracting with your clients are really, really important. So yeah, it's important to get it right. And if you've done the right thing initially with your contracts, it will actually be cheaper, easier, and quicker for you to recover your debts. Conversely, if you haven't done the right thing, it will end up being more difficult, which kind of equates more expensive, really. So, you know, if you get this part right, your life will be a lot easier. And, you know, it might be that you don't think you really enter into contracts with your clients, or maybe you think, you know, we just have informal agreements or arrangements, but contract really is just a word for agreement. And every agreement that you enter into with your clients, whether it be verbal or written, is a contract. So, you know, issuing an invoice to a client with terms and conditions on the back, that's a contract. Some of our clients think that might be too onerous. They're just issuing an invoice with, you know, a link to some terms and conditions on the website, but that's a contract as well. So I guess all that is to say that there's many different forms that your contract can take. But when the customer actually defaults and fails to pay you, you're relying on that contract to get your money back. So you'll come to us and we'll have to go to the court and say, well, look, this was the agreement. The customer, client didn't comply with the terms of the agreement, so you're entitled to some money back. So yeah, like I've said a few times, the quality of the contract is quite important. So with that in mind, I'm just going to give you a few pointers as to what you should be recording in your contracts at the very minimum. So obviously this could vary a whole lot depending on what type of business you're in and who your clients are. And it's not an exhaustive list of what should be included in a contract. It's just a few things that I guess we wanted to point out that would make your life easier from a debt recovery perspective. And I guess the theme of this part of the presentation, as you'll see, is having these items included in a contract, I guess, serves two purposes. So firstly, there's pressure on the other side, even the time of happens, which if you're running a business is what you want, and people avoid you, come see us to recover debt for you. And the second function of these contract terms is it actually gives more options when when someone defaults, we need to so also if you don't have a good pro forma contract ready to go, or if you have one that you want to have reviewed, we can help you out with that, so just let us know. So at the very minimum, you want to record the parties. And this seems simple, right? But you'd be surprised how frequently people get it wrong. You need to think, am I contracting with a person or is it a business? If it's a business, I need to get the entity. So you need an ACN or an ABN. You can't just contract with a business name. It's important to know that stuff. And you should actually consider as well which entity you've been given by your client. So it's not uncommon for an accountant to set up a trading entity as well as an asset holding entity. So you might want to ask some questions about the entity that you're contracting with. Has that entity been set up so that it can be liquidated in a way that won't impact the rest of the business? And if you don't feel comfortable asking your clients about that sort of stuff, you can do an asset search. Really easy, really quick. If you don't want to do it, we can do it for you. Just do some investigations to find that stuff out. Something else I actually just wanted to touch on about parties. So if you're invoicing a client regularly, you have an ongoing relationship, and they come to you and say, oh, can you start invoicing another entity? That might be a benign thing, or it could be a sign that they're in trouble. So I've had it twice recently where that occurred. Our client started invoicing to another entity, then a few months later that entity gets wound up, and then you're trying to get money back and it's very difficult. So maybe just ask some questions. It could be nothing, but it could be a danger sign. So next, you want to record payment terms and price as well. This is another one. It's very simple, but you'd also be surprised. You need to record how much is due, when, and how it should be paid. And like I said at the start, so the quality of your contract is very important. This is the document that we're taking to court and saying, well, the other side didn't comply with the terms. So if you don't have things like this reported, it's not, we can work around that, but it just is a little bit more work for us, which means you have to spend more money. And in payment terms as well, you might also consider including some interest provisions, so on overdue payments. So that also motivates your clients to pay you promptly. Next, it's a good idea to include some security or director's guarantees if you are contracting with a company. That way you can avoid a situation where a company goes insolvent and then you're left sort of, it's more difficult to recover your money in that circumstance. It also gives us an additional person to sue if you come to us. And not to be callous or anything like that, but I find if you do have a personal guarantee or a director's guarantee and that person's faced with bankruptcy or the sale of one of the properties that they own, they're more willing to come to the table and negotiate with us. So it's very handy to have. And if you do have director's guarantees in the contract, you just need to make sure that you draw this to the attention of the other party. So I don't want to go too down into the rabbit hole of legalities, but these types of clauses are more difficult to enforce the less visible they are. If you have one in your contract or you want one drafted for you, that's actually possible, you can let us know and we'll help you out as well. Next, PPSR registrations. So if your business is involved in selling goods on retention of title terms or leasing out goods to other businesses, it's worth getting a PPSR registration because this allows you to register your interest in the goods on a national database and it can be tracked. But if you do have clauses relating to this in your contract or you are doing PPSR registrations, this is something that you really should have a lawyer help you with or look over because it can get complicated, and the PPSR registrations can be invalidated for very minor things. So that is not a good situation to find yourself in. And with the PPSRs, there's a range of advantages to it, but I can't really go through all of them in this presentation. But I did just want to highlight one of the self-help remedies that's available under that Act. So Section 123(1) of the Personal Property Securities Act provides that a secured party may seize collateral by any method permitted by law if the debtor is in default under the security agreement. So you can rely on this provision to actually go in and recover your goods that you've leased or sold to a company. But it doesn't, it's subject to laws such as trespass. So if that party doesn't let you onto your property, onto their property, then you can't break the law to go onto their property. What you can do is bring your PPSR to us, and we'll go to court and say, look, we've got this PPSR, we need to get onto the property and recover the goods, and the court will help us out and give us an order to allow that. So that's really good in a situation, say, these goods to a company, they're of a relatively high value, that company is about to get wound up, and you just want to get your property out of there as quickly as possible to avoid getting tied up in the liquidation of the company. And we did that recently and it worked really well. So indemnities. So next, you should include some indemnity provisions. So these will protect you from a costs perspective if you do need to outlay money on lawyers to recover your debts. So without indemnity provisions, or if you don't have a contract with indemnity provisions in it, and you go to court and you're successful at trial, you can recover maybe like 60 or 70% of your costs. But if you have an indemnity clause in there, then you can recover a higher amount. So it's just helpful from your perspective to be able to recover those costs. Finally, you should have a termination clause in there that just basically says, under these circumstances, the contract will come to an end, and this is what will happen. That'll vary a lot depending on what the contract is and what you do, but it's very helpful to have that in there. So, just to kind of sum this section of the presentation up. So, like I said before, the reason that we include each of these items into the contract is because each one kind of adds a layer of pressure to people to pay you on time. So if you've got interest provisions, directors' guarantees, PPSR, enforcement costs payable by the other side in the event of a default, then they'll obviously think more carefully about failing to pay you on time. So this is kind of like a preliminary protection step for you that you can take to, avoid the need to recover debt in the first place. And also it will help with cash flow, which I guess is important to all business people. The second advantage of all these clauses is that when someone does fail to pay you, or if, hopefully they don't, but if they do, then we've got more options as lawyers, right? If we've got a director's guarantee, there's another party to sue. If we've got the PPSR, we can just go in and get your property back for you, and then you're not stressing about that, so we can work on the debt afterwards. So all these types of things will help you out a great deal in the event of a default. So now I'm going to talk about self-help remedies. So these are things that you can and should do if someone doesn't pay you money before you come and see us. And just like the last section, these are things that if you do properly, will just make the process a bit easier and quicker if you need to come and see a lawyer. And it's pretty straightforward. I'm sure people in this room are engaged in this sort of stuff all the time. So informal correspondence with the debtor, you can send emails, text messages, phone calls, have meetings with them to discuss the debt. If you do have a phone call or a meeting, it's best to just make a file note of it. So say on this date, I met with this person, we spoke about this. Because as Alicia will tell you, when you come to see a lawyer, you'll need to handle this sort of stuff over and we'll need to show it to the court. And with that in mind as well, since it's going before the court, just be careful what you say. Just be polite, courteous, and keep it to the point. And it might also be worthwhile actually considering having some sort of pro forma letter that goes out to debtors when they're overdue. Say, they're 30 days overdue, this is the letter we send to every debtor, so it's systematized for you and you're not really stressing about what to do. So this is something you can do yourself, or we actually offer a service as well to send out like a free debt recovery letter. There's some information about it in your packs. So if that's something that you need, you can let us know. And finally, so you can actually meet with the debtor and into some sort of payment arrangement. So I guess just use your commercial judgment if you're doing something like this. If it's a good client you trust, and maybe it's not a huge amount, you can extend the payment terms or whatever. But then if it's someone that's perhaps a bit more dodgy and it's a large sum of money, you might want to think more carefully about whether you enter into the arrangement at all, or getting a lawyer to draft up the agreement. So like a good payment arrangement agreement will have some clauses in it that just make it easier for you or your life easier in the event that that person fails to pay you. So just things to think about, but I'm sure you can use your judgment as to when and where that'll be appropriate. And so just to finish up, so what not to do. And this is brief, but just because someone owes you money doesn't mean that other laws don't apply to you. So, don't rock up to someone's house at midnight threatening them, don't yell at them, don't harass them, just be courteous. Because, if you do engage in any of these types of activities, you'll be calling a lawyer, but you'll have a much bigger problem to deal with than just a debt. So thank you, that's all I have to talk about. So I'll hand back to Lisa now.
All right, thank you, Lachlan. So I'm going to deal with what steps you might take once you've gone through hopefully those processes. You've already been to a lawyer, you've ensured you've got some excellent contracts in place, and you come to see us, you've already got interest provisions, indemnities, and the ability to sue not only the company that you're dealing with, but also the director. Maybe not, maybe you've hardly got anything, maybe you have an oral agreement. Either way, that's the sort of thing that I'll be looking at when you come to see. And we would first meet, and hopefully on that first meeting you would collate these sort of things. So you might get together documents that might comprise the contract. They might not be a detailed agreement. They might be the invoices, the quotes, the estimates that you provided, and then there'll be statements of account, there'll be email communications about what was owing, and there'll be evidence of some payment, hopefully, that's been made. All those things comprise evidence that I would want to look at when I'm formulating a claim or advising you on how you can proceed against someone who owes you money. You'd also want to produce evidence or give me instructions on evidence about the evidence of services and goods provided, so that I can assess whether there's any potential claims back against you in terms of a defence or a set-off or a cross-claim. And I would usually want to see all of the communications that have passed between you and your opposing side, particularly as regards any reasons for failure to pay, because I'll be reading those with a critical eye to assess whether there's any dispute about the debt or part of the debt, because that will inform us as to the sort of debt recovery action that we would recommend that you take. Okay, so what we would do first is usually send out subject to the nature of the matter, depending on how complex it is, the amount of the debt, whether it's disputed, we might send an initial basic letter of demand. Surprisingly, sometimes just informing the other side that you've engaged a lawyer shows that you're serious and they might just pay. It really does happen often. Otherwise, we would be looking, assuming it's more complex, we would be looking into giving you a formal advice, assessing the information that you provided, giving you a formal advice about the prospects of recoverability, and also looking into the assets of the party that you're potentially suing, identifying, as Lachlan's talked about, the proper entity that you'd be suing, whether it's a company, partnership, individual, and whether they're still trading. There's lots of considerations that we would want to take into account before we take any steps. You may already have done some searches on recoverability, but that would usually be something that we would do with you. ASIC searches, real property searches. Never underestimate the power of the internet. Check if the other entity is still trading. Do a Google search, see if they're still operating from those premises. All of these are warning signs that they're in trouble or they can't pay, or and will again inform us about the type of action that we might take. And we'll always encourage you to explore early resolution. Get the parties in, see if they've lawyered up, get everyone into a room and try and have a discussion. Some of that might be prompted informally. Otherwise, we would instigate the pre-action steps that are available under the court rules, which I'll go to next. But I first want to touch on some interim remedies that are available, what you might do if you genuinely have reason to believe that the person's gone underground, or the company, usually a person, gone underground, disappearing, won't pay for that reason. And also, if you have any claims that might fall under the Building and Construction Industry Security of Payment Act, this Act provides a more immediate avenue for pursuing liabilities if you have incurred those expenses in connection with construction work. And the definition under the Act is fairly expansive, from building, renovating, labour work, architectural work, surveying, engineering, landscaping, even painting, all forms of installation in connection with buildings, power supply, water supply, air conditioning, security. It's really expansive. So if you've provided services and haven't been paid under that Act, and they fall under that Act, rather than going through the mainstream court action proceedings, which if contested maybe will be done within a year, you can issue what's called a payment claim under this Act if you come to me within 6 months of the completion of the work or the last invoice that was raised. Payment claim is something that once you've done it a few times, you can do on your own, but you may ideally get legal advice on preparing it to ensure you don't make a mistake. For instance, with particular reference claim that you use, there's some particular things that need to be correct. So you issue your payment claim specifying what the work's for, how much is owed, you serve it formally, and then under this Act, the party that's served has 15 business days to provide a payment schedule. And what's required in the payment schedule is defined under the Act, but it must nominate which parts are admitted and will be paid and which aspects are contested. So if there's any payment to be withheld, why? And to set out precisely what the basis of any defect or basis for withholding payment is. If your contracting party fails to provide the payment schedule within 15 business days under that Act, you have a statutory entitlement to enter judgment on that debt. So that's a pretty immediate remedy, which immediately strengthens your position, and they cannot then, what would happen is we file the claim in a basic sort of form and an application for what we call summary judgment, and they cannot raise any basis for defence or counterclaim in response because if they fail to raise those issues in a payment schedule. So it's a really useful Act to make use of if you're working in any sense in the construction industry or supply of services in connection with the construction industry. Also, that Act provides for contested parts of the dispute to move straight to an an adjudication. So it's not within the courts as such, it's an adjudicator who will have experience in the construction industry, and the parties will be brought together to resolve their dispute in a more immediate fashion. This Act first started in England and then was rolled out here to relieve the backlog of construction and building dispute matters that were in our court system that just weren't resulting in a fast outcome. And when you're dealing with the construction of a property, it's completely on hold because it's in a backlog in the court process. It's just a really unfortunate scenario. So I encourage you, if you can utilise that Act, to be alive to it. There's lots of information available online, or contact us and we'll give you some more advice on whether you fall under it. So when you come and see a lawyer, one of the reasons to come to a lawyer early is to explore whether you have any interim remedies. There are a lot of interim remedies, but one of the things that might apply to a debt claim or a liquidated claim are freezing orders. I'm sure every litigant would like to have the benefit of security for their potential claim, but you're really only able to get a freezing order, which is effectively an order of the court restraining the other side from removing their assets, whether inside or outside of Australia, from disposing of them or dealing with them or in any way diminishing their value. But it's intended only to preserve the status quo and prevent dissipation of assets that would otherwise be available to satisfy judgment. An application for a freezing order can be made at the commencement of the proceedings or any time during the proceedings, but they're only available in these circumstances where, as the claimant, you can identify that you have a good arguable case and that you have produced, this is a critical one, that you've produced evidence of the other side's attempts to dissipate their assets. And this isn't just selling their property at market value. It's not designed at that. It's where perhaps there's transfers at undervalue to related parties. If you know they're setting up some sort of Phoenix operation, they've stopped trading under a particular name, the wife's now trading under that name, that sort of scenario. It really is only used in extreme sort of situations. I had a matter where we were instructed on a joint venture agreement to set up a manufacturing and exporting baby infant milk powder factory. And the disagreement arose between these investors, one of which was very much on the ground, hands-on, the other one, and the dispute arose about levels of contribution. And the party on the ground set up a new company, removed all of this equipment and put in a new facility in another place. We got freezing orders against them. It took us a long time to identify where this other factory was, but we got freezing orders against them, and a year later succeeded in getting at trial in getting judgment against them for proprietary relief into the assets in that business, but also damages for breach of fiduciary duties and for knowing assistance sort of claim. So there really are, it's really in extreme situations, but that's a key reason why you might come and see a lawyer early if you have a reason to believe that someone you're intending to pursue in court is shifting their assets around. All right, so I think I've covered everything on that slide. I'll just move on to pre-action steps. I'll just touch briefly on, other than dealing with the assets, so freezing orders without movement in assets, there is actually power under our Enforcement of Judgments Act to deal with an absconding debtor. I've not personally used this one, but if you believe, if you're dealing with an individual who's not engaging, gone underground, maybe moving out of the state, out of the country, there is an ability to go to court, produce evidence of that conduct, and the court will issue a warrant for their arrest. It's only executed by the Sheriff's Office, so they don't have the ability to formally arrest them like a police officer may, but they can hold them before the court for examination. And the remedy that's available to you using that power, if the court's satisfied, they might make an order that that party provides security equivalent to the value of your claim paid into court in what we would call the suitor's fund, to preserve some cash available for you because you're worried about whether they'll engage in proceedings if you do bring them. So let's assume that we don't have an absconding debtor and someone who's trying to hide their assets or transfer them to related parties out of your reach. So we have fairly rigid now pre-action requirements under our court rules, which came in 2020 under Chapter 7, and they will govern the steps that you're required to take before you issue court proceedings. So really it's just how you're supposed to give written notice of your intended claim before you launch into court proceedings. You can't just immediately issue court proceedings. And they're really brought in by the courts to encourage parties to negotiate, try and resolve their dispute before they start running up legal fees and once you get into court, it's very difficult to get out. So they're just really to encourage you to try and resolve your disputes before you run up legal fees. Bring the parties together, make sure insurers are notified, make sure third parties and related parties are notified of potential claims. So there are two types that I'll talk about. There's final notices. Yeah, so on this slide. So a final notice is a notice that might be served requiring payment within 21 days. You would only issue a final notice if, and it's a much more briefer form, if you have a reasonable belief that the claim is uncontested or not genuinely contestable. I provided some services, I issued invoices, I'm due payment, they haven't even complained about my services. Why don't they pay? I have no idea why they pay. They haven't raised any defence, no basis for non-payment. And in those circumstances, we would encourage you just to do a final notice. In those circumstances, there's no obligation to have the formal meeting, which I'll talk about in a minute. It's just issue a final notice, 21 days, they fail to pay or fail to negotiate with you, you can get on with issuing proceedings. Hopefully the lawyer letterhead and the court stamp of a final notice prompts them to negotiate, and we then enter into a settlement agreement, the terms of which permit you to enter judgment if they default, and we've immediately got an enforceable judgment. Ideally, that's step one and an outcome that we'd be aiming for. Let's assume that we have a more complex claim and you present to me when you come and see me a whole lot of emails where they've raised defects about or alleged issues with provision of service, that they didn't like something you did, or something about the provision of service is usually what we would see, particularly in a debt recovery sort of matter. Then we would issue what's called a pre-action notice. The requirements for a pre-action notice, it can just be on a letterhead. Usually we would serve it with a draft statement of claim, So it looks like we've got a court document ready to go. Other side will take it more seriously. You're obliged to specify the quantum of your claim, provide sufficient material to enable the other side or the lawyer that they retain to understand what the claim is about and how the claim arises. So you would enclose any contract or agreement or a lease, whatever it might arise from, the basis on which you calculate the liquidated sum or damages. You might provide copies of the invoices, anything that will permit the other side or the lawyer that they retain to immediately understand the nature of your claim. You're also obliged to attach a cost estimate. This is what you anticipate the matter will cost if court proceedings are issued, steps that are involved, and up to and including trial. Your pre-action claim must include an offer, and the terms of offer must be capable of giving rise to a legally binding agreement if accepted. So that usually under the rules, a response will be required to that pre-action claim within 21 days. It's called a pre-action response. And then the pre-action claim also would include a proposed date for a meeting. And that meeting is not usually attended by a formal mediator or an independent party in the mediation sense. It's usually like an informal settlement conference. Usually you would attend with representation, so you would have your lawyer, they would have their lawyer, it would just be at our offices in a boardroom with a breakout room, and we would conduct it like a mediation but without the formalities of a mediator. There are some requirements under the rules for things that we need to go through at a pre-action meeting, including discussing, obviously it's a negotiation, but and everything that is discussed at that meeting would be without prejudice. So it provides an environment in which you can discuss openly issues about the services and why you might not have made payment, and put offers on the table that then cannot be relied on later. If you can't reach an agreement at that meeting, there are the court rules require you to consider and confer with the other side about anticipated steps in the court proceedings, including what likely witnesses you'll call, whether there's expert evidence required, how long trial might be, and anticipated costs. In practice, some of these discussions are a bit artificial, but they are the requirements that the court expects us to go through in a pre-action meeting, and there is a form that we even have to fill out that would then later be lodged with court. So this is a step that these steps need to be undertaken, and failure to comply with these pre-action steps may stall proceedings when they are issued, including the calling by one of the parties or the court of its own initiative a special directions hearing. It may result in the proceedings being stayed until these steps are undertaken, and it may result in cost orders being made against a party who failed to engage. For example, if I settle a pre-action claim and the other side just refuses to provide their pre-action response or refuses to meet, waited sufficient time, I'll advise you just to issue proceedings, and then the court would force them to engage in this process. Obviously, you can never force a party to negotiate, but you just keep trying. And every step that we're talking about today is a tool in which to apply pressure to try and get someone to come to the table, because all these are, every single one of them. So just touch on concept without prejudice. I'm sure you're familiar with it. It's a common law concept, common law privilege, but it's expressly provided for in our Evidence Act, and it precludes the production of oral or written statements that are made in a settlement context. So long as you're engaging in settlement negotiations, whether that be by letter or meeting or phone call, those communications cannot be relied on or forced to be produced then if you're even caught. And I do see people perhaps just slapping without prejudice on all manner of communications. It has no effect unless the communication is in the context of settlement negotiations. So use it by all means. Be alive perhaps to the extension of that expression, which is without prejudice save us to costs, because the beauty of these communications, if you commence, before you commence proceeding, if you send a letter saying these are the reasons why I'm going to be successful in court, and notwithstanding, in the interest of avoiding court proceedings, I'm prepared to settle for X, and you mark it without prejudice save us to costs, happy days. We win a trial, we beat that offer, and I can produce that letter and go, they were given an offer to settle for this, I've beaten it at trial, and you're likely to then get your indemnity costs from the point that we sent that letter. If you marked it without prejudice and didn't put savers to costs, can't use it. It's not producible. So it needs to have savers to costs, otherwise it's permanently privileged from production in court proceedings, at trial, and on a costs argument. And that's something that you might have to be mindful of when you're trying to protect and cost protective offers. All right, so that's debt recovery in a nutshell. Then you have to issue court proceedings. When you issue court proceedings, you will need your way you issue court proceedings will be determined by the quantum of your debt. So if you have a claim that's 100,000 or under, you'll be in our magistrates court, which is a bit of a people's court. They refer to it as, if it's 12,000 or under, it's minor civil. If you get to trial in a minor civil matter, you'll need to represent yourself. Or if you're a company, you need to represent yourself. A director, we need to represent the company, unless both parties agree for legal representation to be used and the court agrees. But it's very unusual for claims under $12,000 to be to have lawyers. You can get guidance through the stages of proceedings, but you would have to litigate it yourself if it's under 12,000. So 100,000 and under in our magistrates court, above 100,000 you're in the district and supreme courts unless you go into the federal court if you're utilising a common law statute. And ideally, what will happen is we'll issue, assuming it's a straightforward debt claim, we issue your claim, comply with the pre-action steps, we issue your claim, and first thing that might happen is with effective valid service for the purposes of the Act, whether that be personal or on the registered office of the company, and they fail to file a defence. So in default of defence, we can enter default judgment. That's as good as a judgment that's obtained at trial, and it enables you to proceed with enforcement steps that are available to you. It's a rubber stamping exercise. You don't have to go to court and argue for your default judgment. It's an application that can be made on online. Our paralegals do it for us all the time, where people refuse to file a defence or fail to engage with the claim. All we need to establish via affidavit of service from a process server is that we validly served your claim, and that 28 days has expired for filing defence. If they fail to file it, we're entitled to enter default judgment. Then we have the default judgment in our hand, and we can take steps to issue a bankruptcy notice, which I'll come to later. And one of these steps might result in your debtor engaging, and that's again what we're just trying to motivate the debtor to engage with you. So sometimes a claim won't do it. A default judgment served on them might, maybe not. Bankruptcy notice usually definitely does. So we're just trying to get to those steps where they take some steps, and believe you me, you'll be surprised how many steps we go through before someone goes, "Oh, I didn't get that." But yes, you did. So we have a bit of fun around that, or rather frustration. So a respondent, while it's as good as a judgment obtained at trial, a respondent can apply to set aside a default judgment if they can establish not one but both these tests. So firstly, that it was irregularly obtained. Usually that's about service. So that's hard to prove if we've got an affidavit of service of an individual that personally handed it to them. But if it was served by other means, for instance, registered post or email, and they can say that they didn't receive it because they were in another country, or it was, there's different arguments that can be raised. They'd have to establish that they didn't receive it, they really didn't get notice of the claim, and that's why they didn't file an offence. And they'd also have to prove to the court that they have a reasonably arguable ground of defence. So with a debt claim, that's going to be pretty difficult unless they genuinely have a basis for raising a genuine reason for not paying. All right. The other alternative might be summary judgment. So if we filed proceedings on your behalf and the other side has filed a defence, but it really just looks like an attempt to stall, there's no genuine grounds of defence, it's straightforward, we can still, instead of a proceeding to trial and all the stages of court proceedings, we can apply for summary judgment. It's really only available where it's uncontested and there's no reasonable argument, ground of defence. But it's certainly available in a straightforward debt claim, and we frequently apply for summary judgment. If your claim results in a defence and then there is a genuine basis for a defence, for genuinely contested proceedings, for example, like I said before, defects or delays in services, or perhaps alleging termination for breach of contract, giving rise to damages, so they brought a counterclaim and we end up in a position where there genuinely is competing claims. The steps that are involved in court proceedings are the filing of pleadings, so claims and defences, replies, counterclaims, defences to counterclaims, and then we would go through the court documents to find what's actually in dispute and has to be determined at trial. Discovery is the process of producing evidence. There'll be a process of giving over all the documents to the other side that you have in your possession. That extends to other parties who might have documents that are relevant to the claim, potential witnesses, banks, your agents, any number of different parties that might be called on to produce documents. It's unlikely there'll be expert reports in a straightforward debt claim, but I have seen it before, but there might be rather expert reports about services provided, for instance, engineering reports, if I've been involved in matters perhaps in chasing costs for installing concrete floors, and then we had to bring in engineers about the plans and the concrete floors, and it gets overly complicated, and then it very much falls out of the straightforward debt claim category. Mediation is an option that's available at any point in time. Strategically, there are stages when you would usually explore it, and it's usually by agreement, but you can apply to court for a court-ordered mediation if you find that your other side won't engage. What's involved with trials will be beyond the scope of this session, but trial, if you're forced to go through trial and can't resolve at mediation, it will be a process at court where the court looks at the documents and the oral evidence and makes a finding. The length of trial is determined by how complex the issues are, number of witnesses, and the extent of documentation. Assuming you go through trial and you receive your judgment, then you're in the position that's any of these steps, so default judgment, summary judgment, judgment from trial, then we're in a position where we can enforce. So I'm just moving now for the final session onto enforcement steps available to you. Again, the type of enforcement that you will explore depends on the type of respondent that you're dealing with. Are you dealing with an individual? Are you dealing with a company? And I hope that you've put considerable effort into assessing your recoverability prior to this stage. It would be an unfortunate situation if you got judgment and then you started exploring whether the other party could satisfy judgment. So that's a step that should be taken, constantly reviewing whether they've got the capacity to satisfy judgment. I'm sure most litigators have got a horror story of the company on the other side going into liquidation during trial, or prior to trial, during trial, had the other side go into liquidation 2 days before trial, and then you've lost everything and you've incurred significant legal fees. So be aware, check they're still trading, run searches constantly before you engage in all of these processes. So assuming we've got judgment, the steps available to you are court enforcement processes under our court rules and the Enforcement of Judgments Act, or bankruptcy and winding up. So under the Enforcement of Judgments Act, if your judgment is over 12,000, the steps available to you are more expansive. You need to take these steps within 6 years of obtaining judgment. So if it's a debt under 12 million, which is your 12 million, 12,000, and as an individual, the enforcement options available to you are less. You can really only just go for an investigation summons, call someone in to, that's a summons that the court requires a person to come to court and examine about their capacity to pay. So I'm going to assume for the purpose of this presentation that it's a judgment debt over 12,000. And you can then apply to court for the issue of an investigation summons. It's really, the first one is called an investigation summons. subsequent ones are called examination summonses. We retain solicitors that do these examination hearings for $30 a hearing. They attend the local courts and examine individuals about them, about their capacity to pay a debt. And it may result in a payment order being made, which is an instalment order, voluntarily or by order of the court. Or it will, and it's a useful first step, so that's public examination. It's a useful first step to explore if you don't have a great deal of visibility about their capacity to pay, because it might, public searches, publicly available searches would already have identified that if they own assets in their own name, such as real property, and you might then not worry about public examination summons. You might just proceed straight for applying for a warrant of sale. So if you've secured judgment against someone or a company or a person who knows got real property, you would simply apply possibly for a warrant of sale. Again, if you're served with a warrant of sale, you don't have to, if you serve someone with a warrant, if you instruct a sheriff, obtain a warrant of sale, sheriff executes it, there's still possibility for negotiation. Everything, you're really at the end of the line now, but if someone's faced finally with I'm going to lose my home, they might then go, okay, I'll enter into a payment arrangement. And we come across this situation where there's a warrant of sale on someone's property, but it's 2 years old because it's stayed and it's sitting there while they're paying that judgment debt. So it's a useful tool to secure payment. Then under the court process, we've also got charging orders, which are similar to a caveat. It's a gives you priority. The court orders a charge that can go over real property. I haven't used it myself, but there is a powerful point of receiver. It might be useful if there's a specific asset that you want a receiver to be appointed under the court's powers to enter, to take steps to realise an asset to satisfy your judgment. And see a bit. Do you need to turn the heat? That's very toasty. Everyone okay? Obviously, the second topic. All right, 10 minutes remaining to discuss bankruptcy and winding up. Okay, can I do it? Bankruptcy is only, I came across this when I was doing my research. The word bankruptcy actually originates from Italy in the Middle Ages, and it comes from the word banco rotto, meaning broken bench, because a trader's trading table would be broken by creditors to prevent him or her running up additional debts. Rude words. Bankruptcy is only available if you have a judgment debt. Okay, so it's only available against individuals, only available where you have a judgment obtained through court processes in one of the ways I described before, only available where the sum is over $10,000, and only if you take steps to enforce a judgment within 6 years. Again, try and negotiate, threaten it, then do it. You use AFSA, the Australian Financial Security Authority, to release or issue a bankruptcy notice. Under Section 40 of the Bankruptcy Act, there are many parts of conduct that might amount to an act of bankruptcy, such as conduct which is removing an asset from the jurisdiction to defraud creditors, but the most straightforward and common used basis on which to issue bankruptcy proceedings is to issue a bankruptcy notice, which requires payment of the judgment debt within 21 days. Failure to do so is an act of bankruptcy and permits you to issue a creditor's petition. That's a document that's endorsed by the court. We usually issue them in the federal court. And it will result in the listing of a hearing at which a sequestration order will be made. It's a bankruptcy order. And what can the bankrupt do? Not much. They've already got a judgment against them. So when they're faced with a bankruptcy notice and a creditor's petition, it's pretty difficult for them to then take any steps because they ought to have taken those steps in the underlying proceedings. So we end up with a real scramble where they're desperately trying to either set aside the primary judgment, which is often of limited utility. So they could attend court and try before the expiry of the creditor's petition, and they would need to oppose. So if they wanted to oppose the creditor's petition, common grounds might be that the debt is not owing. A bit late to do that now, but there might be a basis, or that they have a set-off. They're not permitted to raise a defence or basis for set-off that they should have raised in the primary proceedings. So things are looking pretty bleak right now for them. Or they can challenge the act of bankruptcy, as I said, under section 40. That's fairly difficult, where it's the issue of a stat demand and they failed to pay within time. Or they can prove they are solvent and have an ability to pay the debt. Really, that's just, can I please have more time to pay? So that's happy days for us if we're at that one. If bankruptcy is a new concept to you, I'll just touch on the consequences for the bankrupt. It's a fairly serious remedy, so it shouldn't be explored lightly. The assets of the bankruptcy will fall to the control of the trustee appointed on the sequestration order, and they can then, the trustee can take possession of and sell the assets of the bankrupt. It's more than likely that they would lose their home, subject to communications between the trustee and bankruptcy, the level of equity available, and any preference of any first registered mortgagee or any co-owners. A bankrupt is entitled to keep certain assets subject to their personal circumstances, including the number of dependents. They keep their household personal items, income up to an indexed amount, depending on that individual and how many dependents they have, their tools of trade up to an indexed amount, their vehicles, so long as the unfinanced portion is not more than 8,500, pretty low, funds in super, and if they've got long-standing accounts that are held on trust for their children. Other consequences for bankruptcy for the bankrupt include restrictions. Usually they have to hand over their passport and they can't travel overseas without consent of their trustee. It's difficult to apply for credit or enter into other commercial arrangements, such as hire purchase arrangements, or even secure rental accommodation, because you have to disclose that you're a bankrupt, undischarged bankrupt. They cannot be a director while they're bankrupt. Partnerships are dissolved as a result of bankruptcy of one of the partners, and even after the 3-year period, that's the minimum that the bankruptcy period will be, their name will permanently be recorded on the National Personal Insolvency Index that they were bankrupt. The trustee has power to investigate, the trustee in bankruptcy has power to explore and investigate transfers of property up to 5 years prior to the bankruptcy. If they were transferred under market values, there might be actions against third parties, particularly if they're related parties. I'm running out of time, so I might just quickly touch on winding up. So if you are dealing with a debt against a company, different from bankruptcy in the sense that you don't have to have a judgment debt. If you're proceeding in the New South Wales Supreme Court, you want to have a judgment debt. It's fairly frowned on there to proceed without judgment debt. It does need to be a debt that is undisputed. So the most common basis on which to apply for a winding up order against a company is if they fail to comply with a creditor's statutory demand. That creates a presumption of insolvency. There are pretty strict requirements under section 459E of the Corporations Act. The debt or debts against that particular company must be due and payable and must total at least $4,000. The demand is in a specific form, but the form is in the Corporations Act, so you can find it there. It must be in writing, must specify the debt, and that payment must be made within 21 days, the statutory period from service, must be signed on behalf of the creditor. If it's not supported by a judgment debt, the demand must be accompanied by an affidavit that verifies the debt is due and payable by the company. So the debtor company's options from there are to comply with the demand or apply to the federal court usually for within statutory periods. So they must apply to set it aside within 21-day period provided under the statutory demand. That compliance period has been strictly applied by the courts, and there's no extensions of time or dispensation with these requirements that can be given. The court may set aside a statutory demand if there's a genuine dispute about the debt, or the company has an offsetting claim, or there is a defect in the demand that would cause substantial injustice. Unless set aside, for any issue, you might just agree to withdraw it and issue a new stat demand to get on with the process again, so you're not caught up in a complex argument on an application to set aside, because you just start your 21 days again with some technical argument in my opinion. Where a winding up order is made, a liquidator will be appointed and the director's powers cease. All the assets of the company vest in the liquidator, who will be able to take steps to realise the assets for payment of creditors. So at that point in time, we really step back and just wait for what it can be recovered by the liquidator. They'll assess the company's financial affairs. They'll assess claims against company directors, establish claims against any debtor company, gathering all the funds. They'll report to you as a creditor. They'll realise the company's assets to pay outstanding debt, pay creditors in order of priority. They may pursue claims on behalf of the company. They may seek funding from you as a creditor to do so. And then at the end of the liquidation, they'll deregister the company. I am pretty much out of time, but just so you're aware, any debts, we're pursuing a company that's liquidated, there will be carve-outs for any secured creditors such as mortgagees, and anyone who has a interest in our registration will be able to be protected. And then the order of priority for any monies that are realised by the liquidator will go to firstly liquidation costs, unpaid wages and super, and other outstanding employee entitlements such as redundancies. And then it will go to you as an unsecured creditor, and finally any shareholders. So you do stand down the line, but there may be a recovery if there are assets of value it's worth incurring. I should probably say we generally guesstimate around $5,000 for the cost of start to finish, including the court fees of doing a bankruptcy or a winding up. And then you hopefully would have had some transparency already about whether you're likely to get a recovery if there's some assets of value held by either the individual or the company. I hope that's been useful. I mustn't finish this without saying I've assumed that you're the creditor, and if you are faced with a claim or a payment claim, do take it seriously and do engage, because it is much more costly if you put your head in the sand and stop. And I'd much rather prepare a defence for you than say you missed the time, just pay. Okay. Thank you very much for coming.
Thank you.